All rise. We will obey. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. And we're in open session, Your Honours.
Thank you. Appearances.
Morning, Mr. President, Your Honours. Prosecution, the appearances are the same as on the last occasion, on Tuesday, with the exception of our case manager, Ms. Grace Go, who will join us during the course of the morning.
Good morning, Mr. President, Your Honours. The victims participating in this case are represented today, myself, Oshton Arenstig, and my colleague, James Maria. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same. Mr. Sang is present, and in addition to the team is one Mary Ann, who is a pro bono member of our team. Thank you.
Mr. President, Your Honours, good morning. Mr. Ruto, who is present in court, is represented by myself, Karim Khan, Mr. David Hooper of Queen's Counsel, Mr. Esafal of Counsel, Dato Shamla Alagendra. Your Honours, also I'm delighted to announce that Ms. Lee Laurie is now working as counsel. She's been admitted to the list. She's present in court, as well as our trial support assistant, Grace Sullivan, at the back, and then two pro bono interns, Clara Gerard Rodriguez, and also Mame Diara Bodge, MBODJ.
Thank you. From Nairobi.
Mr. President and Your Honours, Gregory Mutai for witness P604.
Thank you. I see. Okay, all right. Okay, thank you very much.
Mr. President, the registry's representative is in Nairobi too.
Thank you very much. I noticed that. Before we proceed with the rest of with the witnesses' testimony, I will need to read the further reasons for our ruling, partially postponing the testimony of witness 604. Before I do that, I wish to make one matter clear so that there is no confusion in the course of the litigation on postponement of the witness's testimony. References were made by both the Chamber, of course, and counsel for the parties in the case. References made to the statements of witness 604, as well as the affidavit that he filed disavowing his statement to the prosecution. It needs to be stressed that those materials are not on the record of on the merits of this case. The statements of the witness of which we spoke and the affidavit were barely on the record for the procedure of litigating the postponement of his testimony. So if parties in the course of the testimony of the witness want to do anything with the statements and the affidavit, they will know how to go about it in the usual manner. Having said that, we will now read the further reasons for postponing the testimony of the witness partially. On the 2nd of September 2014, the Chamber partly granted Mr. Mutai's request to postpone the commencement of the testimony of witness 604, P604. We indicated on that occasion that we would in due course provide fuller reasons for the postponement decision, we now do so. By way of procedural history, the following may be noted. Witness 604 was required to appear on the 1st of September 2014 to testify before the chamber by way of video link. This was pursuant to a summons to appear sent on the 1st of August 2014, issued on the basis of the decision of the chamber dated the 19th of June 2014. The record indicates that on the 11th of August 2014, the prosecution received an email from Mr. Mutai, representing the witness, with an affidavit in which witness 604 apparently recants the statement previously given to him, by him to the prosecution, and also announcing his withdrawal as a witness for the prosecution in the present case. That affidavit was accompanied by a letter signed by Mr. Mutai in which he announced himself as the lawyer for the witness and similarly communicated the disavowal apparently deposed in the affidavit. On the 26th of August 2014, Mr. Mutai sent an email to the prosecution seeking postponement of the testimony of witness 604 by 21 days in order to enable him take instructions from the witness. On the same day, the chamber, through the registry, having been informed of Mr. Mutai's request, directed that the witness was required to appear in accordance with the summons, but that Mr. Mutai may also appear on the date in question to make any preliminary submissions on behalf of the witness. The idea was to give not only Mr. Mutai, but also parties and participants in the case an opportunity to be heard on the matter should the request be pressed during the court session. On the 27th of August 2014, Mr. Mutai sent an email through which he sought reconsideration of the chamber's direction, submitting that he would require time to prepare. On the same day, the chamber again, by email, rejected the request communicated by Mr. Mutai by email, the request for reconsideration. On the 29th of August 2014, the registry transmitted to the chamber a further email from Mr. Mutai in which he repeated his request for a postponement of the witness's testimony, and in addition to the grounds previously raised, he submitted that the health of the witness and a possible instruction of senior counsel in the matter also warranted the requested postponement. A medical certificate was attached to the email from Mr. Mutai. The chamber reiterated by way of email transmitted by the registry that the witness was required to attend in accordance with the summons, but that it would hear preliminary submission from Mr. Mutai regarding the requested postponement before issuing a ruling. On the 1st of September 2014, the date scheduled for appearance of the witness. Witness 604, together with Mr. Mutai and a standby duty counsel appointed by the registry at the direction of the chamber, duly appeared before the chamber by way of video link. Having consulted with the witness, Mr. Mutai indicated that he was instructed to renew the request for postponement of the testimony. Mr. Mutai submitted 5 grounds for the requested postponement, namely, 1, the health status of the witness, 2, that he had not been provided with a copy of any statement of the witness and consequently was not in a position to advise and to guide the witness during his testimony. 3, the possible appointment of lead counsel to represent the witness in the matter and the need for the new lead counsel to take instructions. 4, time required for the witness to obtain M-Pesa and telephone records to support his testimony. And 5, that having had certain travel documents returned to him only that morning, the witness was not in a good state to testify, mental state to testify, believing that the actions had been taken to intimidate him. The prosecution, the defense team for Mr. Ruto and the counsel for victims opposed the request for a 21-day postponement, but there appeared to be common grounds that the testimony should not commence as scheduled on the 1st of September in the circumstances. And the prosecution and the victims' counsel considered that a 2 or 3 day postponement would be adequate. And Mr. Ruto's defense counsel argued that no more than 1 day's postponement was necessary. The defense team for Mr. Sang indicated that although they were ready to proceed, they were not opposed to the request, but suggested that a period of 14-day postponement may be sufficient. Also, on the 1st of September 2014, Mr. Mutai, following the day's proceedings, was provisionally included on the list of counsel and admitted to practice before this court. On the 1st and 2nd September 2014, the VWU reported directly to the chamber following a vulnerability assessment of the witness. The parties and participants do not have direct access to this report. In summary, it was advised that the witness had been interviewed by a VWU psychologist who formed the view that the witness's psychological condition is not such as would prevent him from testifying. The VWU also arranged for the witness's physical condition to be medically assessed by a physician. On the 2nd of September 2014, the chamber made a ruling granting in part the application for a postponement of the testimony of witness 604 and directed that the testimony would commence on Thursday, the 4th of September 2014 at 9:30 a.m., the Hague time, that is today, which time is 10:30 a.m. in Nairobi. The chamber explained that the purpose of granting the postponement of a further 2 days was in order to enable the VWU to complete its familiarization process with the witness, as well as to enable counsel to prepare. The chamber also indicated at that stage that fuller reasons would follow, which is what I'm doing now. Subsequently, on the 2nd of September 2014, the chamber was notified that the witness had indicated that he did not want to see the doctor arranged by VWU to perform a physical medical examination on the witness. The witness said that he was ready to testify without such medical examinations. Here now are the chamber's consideration of the 5 grounds raised by Mr. Mutai. The first ground argued by Mr. Mutai during the hearing of the 1st of September as warranting the request was poor health of the witness. Regarding the health status of the witness, the chamber notes that in neither the 21-day postponement request nor the request for reconsideration on that matter, as dated on the 26th and 27th of August 2014, respectively, was the held status of the witness raised. In addition, poor health of the witness was not mentioned at all, nor mentioned as a cause for concern in the witness's contacts with the VWU between the 5th and the 27th of August 2014, nor was there any such indication in Mr. Mutai's communication of the 11th of August 2014, asserting the witness's apparent disavowal of his initial statement to the prosecution. It was only on the 28th of August 2014, following the Chamber's email rejection of Mr. Mutai's own email requests for postponement of the witness's appearance on the 1st of September 2014, that the VWU was first informed of such health concerns, and on Friday, the 29th of August 2014, in the renewed request for a 21-day postponement attaching a medical certificate. It was only then that this was brought to the attention of the Chamber by way of a record. It is noted that the medical certificate, which indicates that the witness had been under the care of a doctor for approximately the past month, does not directly address the question of fitness to testify, but advised that the witness should avoid stressful conditions. The Chamber wishes to emphasize that, as mentioned on the 1st of September 2014, we take very seriously our duty to protect the safety and well-being of witnesses. The Chamber has always made this a cardinal duty to manage the hearing of witness testimony in a manner which will minimize to the extent possible any related stress. There are, in addition, a number of practical measures designed to assist witnesses, including, in particular, the witness familiarization procedures conducted by the VWU. The Chamber was also guided in this matter by the independent assessment provided by the VWU, which addressed the specific question of the witness's fitness to testify. On this basis, the Chamber is satisfied that the health status of the witness is not such as would prevent him from testifying in this case. The witness's subsequent indication of readiness to testify and willingness to attend, the unwillingness, that is, lack of willingness to attend the additionally scheduled medical appointment also confirms this assessment. The Chamber will separately consider any specific recommendations of the VWU for special measures to facilitate the testimony of the witness. It is also noted in that regard that the prosecution's request for in-court protective measures for this witness is outstanding, and that the Chamber will also rule on that request once it has heard submissions from each of the parties. The Chamber turns now to the second ground relating to the provision of the witness's statements to counsel. It is noted, with effect from the 1st of September 2014, that Mr. Mutai was provisionally included on the list of counsel admitted to practice before the court and pursuant to the direction of the Chamber, has since been provided with access to the witness's statements. Noting the scope of representation outlined in the Chamber's directions given orally on the 2nd of September, the Chamber did not consider that access to the statements on the part of counsel constituted a prerequisite justifying a postponement, in particular of the magnitude of postponement requested. Mr. Mutai's third ground regarding the possible appointment of lead counsel to represent the witness in this matter was ruled upon by the Chamber on the 2nd of September 2014. In respect of the fourth submission that time is needed for the witness to obtain certain telephone and M-Pesa records, the Chamber considers that the necessity of any such records can be considered as appropriate during the course of the testimony. As noted in the oral submissions, the witness may put in motion an application for access to such records now in order for them to be available as soon as possible when needed. However, the Chamber will only consider this matter further should it become relevant during the course of the witness's testimony. In any event, the Chamber does not consider that it warrants delay in the commencement of the testimony to the extent requested by Mr. Mutai. Finally, in respect of Mr. Mutai's submission regarding the witness's travel documents, the Chamber notes that clarification of the circumstances of that matter was provided during the course of the oral submissions. The Chamber did not consider that it provided any impediment to the commencement of the testimony. That is those are the reasons for the partial grant of the request to postpone. Now we will take submissions on protective measures requested by the prosecution. Ordinarily, these submissions are done in closed session, so we will go into private session, rather. We'll go into private session for the submissions to be taken.
We're in open session, Your Honours.
Thank you very much. We will render a ruling on the request made by the prosecution. The prosecution made the request for protection in court protective measures for witness 604 by their filing of the 28th of August 2014. In the request, they asked for image and voice distortion, use of pseudonyms, in-camera sessions and reductions to public records when necessary to prevent identification. As requested by the Chamber, the defense for Mr. Ruto and Mr. Sang, as well as counsel for victims, made oral submissions this morning. Having considered the specific circumstances of this witness, as well as the assessment provided by the VWU and the oral submissions by the parties and participants, the Chamber considers that the requested protective measures are necessary, not only for the reasons ordinarily canvassed in the past, but also the specific circumstances of this witness about which we've had submissions in the last few days. The Chamber therefore grants the following protective measures: the use of pseudonym for the duration of the trial, voice and image distortion, testimony to be given in private session for any identifying part of the witness's testimony, and should portions of the private session become, there should also be a protection, reductions for private sessions, and there will be classification of such material where necessary. The special measure was also requested by the VWU on behalf of the witness, asking that the image of the accused not be broadcast on the screen during his testimony. The Chamber does not accept that measure. We reject it. That is the Chamber's ruling on the protection measures. Can we now bring the witness in?
Yes, Mr. President. I will bring the witness in.
Mr. Butai?
Mr. President?
Yes. As we said, you may remain seated during the course of the proceedings. But during the Chamber's ruling on the 2nd, you were advised to instruct the witness on the matter concerning self-incrimination and the duty to tell the truth. Did you do that?
Yes, Mr. President. I have advised him on the provisions of Rule 74 of the rules of the court.
All right.
Your Honour, perhaps while the witness is being brought in, may I also remind the Chamber of the necessity to remind the witness of Article 70. As the Chamber is aware, the prosecution has not had the opportunity to prepare this witness, so we have not given any warnings as the witness refused to meet with us.
That is part of what we're going to do anyway. Thank you very much. Witness 604, thank you very much for joining us. Court officer, can you administer the oath, please?
Yes, Mr. President. You can proceed. Read loud. I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you very much, witness, for joining us in our search for the truth in this case. I don't know whether you have been following the proceedings when it was in the public session, but one thing that I tell every witness that comes to court is that this court belongs to them. This is your courtroom. It belongs to the international community of which you're a member. So we want you to feel completely at home, as if you are in your own home. This is yours. The way we do the work is through questions and answers. There will be lots of questions, hopefully not too much of it. But the way the proceedings work through questions and answers, the lawyers will be asking you the questions and you will be doing the answering. The questions begin with the prosecution counsel, who would ask you questions in examination in chief. The defense counsel would also take turns asking you questions in cross-examination. The defense counsel in this case would be counsel for Mr. Sang, Mr. Kigen Katwa, and also counsel led by Mr. Kigen Katwa, and counsel for Mr. Ruto, led by Mr. Kan. They would take turn asking you questions. The victims' counsel, normally, if they applied for opportunity to ask witnesses questions, we will consider the matter at the time. So the prosecution, at the end of the questions from counsel for Mr. Ruto and from Mr. Sang, the prosecution may also ask you questions in re-examination. Generally, that is how the matters go, but it is also from time to time in cases where a witness, if there's an application made in the course of a witness's testimony by the person who is asking questions in chief, in this case that would be the prosecutor, if they have a reason to say, well, the witness is a hostile witness to them, and that is a special terminology in law, and then they may make an application then to cross-examine the witness. So the person who called you may end up cross-examining you, as the case may be. In the particular circumstances of your case, in light of the litigation or the arguments that were made in the last few days, we do not know whether the prosecution may make that application, but it is something I thought I should point out to you as a possibility. In all of this, as I said, there will be questions from you, from the counsel to you, and you have to answer them. The lawyers are doing their job. I thought I should stress that. Their job is not here to abuse you, and when occasionally you watch movies and you see courtroom dramas, you see, lawyers beating up on witnesses, being very aggressive. That is in the movies. It doesn't happen in this courtroom. We do not allow it. We do not allow lawyers to behave like that. So we will make sure that you are treated respectfully by the lawyers who ask you questions. Do not get overly concerned about the fairness of the question, whether or not this law is being fair, whether they're attacking you unnecessarily personally. This is part of our job in making sure that you are treated fairly and respectfully. So listen carefully to the questions asked of you. Make sure you understand the particular question that you have been asked. Think about the answer you need to give to that question and give it. Give that answer. If you basically work with that as a guiding principle, you will be doing well and reducing any stress to you. Just listen to the question, understand the question. If you have the answer, you give it. If you don't have the answer, you say so. Now, you have been administered the oath by the court officer, and you promised to tell the truth and nothing but the truth. That is all, really, that we require of you. It's just that simple. Tell the truth and nothing but the truth. Try not to engage in guesswork. Do the math in the facts. 1 + 1 = 2. Your job is not to give us that 2. Your job is to just give us the 1 and the 1 and the 1. At the end of the day, the lawyers would argue whether or not it adds up to 2 or 3 or 4, and we will come to the conclusion of that. So try not to jump and draw inferences if you can. Stick to what you know for a fact and let the lawyers and the judges do the interpretation of those facts at the end of the day. We are more interested in what you perceived personally, either what you saw yourself or what you heard directly that's relevant, or what you, if it's about your feelings, your own feelings, what we want. We don't want you to the extent possible, be bringing in hearsay, what others said, and that sort of thing. Try to keep those to the minimum. Now, I'm sure the court officer has advised you that the prosecution had applied for special measures to be given to you, and we have granted those special measures. Again, part of all that is to enable you feel at ease in testifying truthfully. We have given you certain protection measures, like your image, your face would not be broadcast to the public. Your voice also will not be directly broadcast to the public. So what happens is there is some technology we have in the courtroom that will distort your facial image that people may see on TV. They may not. The idea is to ensure that people don't know who you are. That's of the public. The same thing would happen to your voice. And we're not using your name directly. We're using the pseudonym, Witness 604. No one knows, members of the public, that is who you are, the name, the real name attached to the pseudonym 604. And we are in private, we will go into private session for certain critical information that may reveal your identity. Now, the reason I'm telling you all of this is it's important for you also to watch out, because we will not be in private session all the time. There are times when we will be in public session. That means members of the public will be hearing your testimony. When we are in that mode, it is important for you to not give out information that may lead people in the public who may know who you are. They'll make it easier for them to identify who is testifying, or even if they don't know you, something that they can put together to identify who you are, information of that nature. You should try to refrain from giving when we're in the public session. It does not mean that you will not give this sort of information. It only means that if it is necessary to give it, you will need to let us know. We will go into private session for that. And that brings us to something that's very important that we do here. There are, apart from the judges you see and the lawyers who will be asking you questions, we have interpreters and court reporters who are also helping to keep record of these proceedings. Without them, we cannot do our work successfully. But we also try to make it easy for them. Try to speak in a moderate pace, do not speak too fast, also not too slow. There is something we call the 5-second pause. That is a pause that we require of witnesses, or anyone indeed who is speaking in court. A pause that needs to be observed between the person who asks you a question and you beginning to answer it.
Mr. President, I do apologise. I don't know if the audio is being relayed to Nairobi. The screens have frozen on our side, and I just wanted to make sure that they are working in Nairobi so the witness can hear what instructions and advice you're giving. But our screens, our monitors are frozen on the video link.
Yes, I hear, Mr. President.
You can hear the audio.
Yeah, I hear you.
Thank you very much. So what I was saying is it is important for you to observe, count in your mind 5 seconds, 1, 2, 3, 4, 5, something like that, before you start answering the question. Are you still with me?
I am still with you, Mr. President.
Thank you. The need for that is to avoid two people speaking at the same time, because the court reporters and the interpreters hear you and me only through their headphones. And so it's only when one person is speaking at a time that they're able to understand what is being said. If you have two people jamming the microphone, speaking at the same time, they will not be able to do their work very well. So it's always important to free up that space, the 5-second pause, before you start speaking. The lawyers also will be observing that rule. It's a rule that we require. It is very, very important, and that's why I spend so much time on the matter. So generally, this is the advice that I give every witness. But in your case, I'm required to also advise you of the provision of Article 70 of the court's statute. Article 70 makes it an offense to give false testimony. That means, again, what I told you earlier, which you've undertaken to do, you must speak the truth at all times, nothing but the truth. If you do not know the answer, you say so. If you do no longer remember, you let us know. I should also tell you that in the course of your testimony, should you at any point feel that the answer to a question you have been asked might incriminate you, you should let me know. You're entitled to raise an objection at that time on the basis that the answer you give might incriminate you. Are you still with me?
Yes, my honor.
Thank you very much. And when you make that objection, I'll be required to make a ruling on it, and that ruling might say, yes, you will still have to answer the question because I will give you a certain assurance, and that assurance being, please go ahead, answer the question. The answer you give may not be used against you directly or indirectly in any criminal proceedings. That is an assurance that is up to the chamber to give to you if we deem it appropriate at the time. But that assurance, as you know, has already been given. We gave it in the ruling we made on the 2nd of September. Nevertheless, if you feel a need to, again, raise the concern that an answer may self-incriminate you, feel free to do so. Your lawyer as well, Mr. Mutai. Mr. Mutai, you there?
I'm there, Mr. President.
Thank you. Your job is also to assist in that regard. That is, in fact, your primary responsibility, and that is why you are retained. When that objection is raised, as I said, we will consider it, but in our ruling of 2 days ago, we gave that assurance. We also, witness, indicated that the evidence you will give in relation to any part that may raise questions about self-incrimination will be given in private session so that it is not broadcast to the public. We've also indicated that your identity is being protected. That also means that any answer you give to that question will continue to be treated as confidential. It will not be disclosed by anyone in any manner, except in any proceeding against you that involves the prosecutor saying you lied while giving us your evidence in this case. That is the only time that such material may be used against you. The accused persons, their lawyers, and the participants, as well as court staff present in the courtroom or who otherwise have access to your evidence, have been specifically cautioned, and I repeat that caution, that any breach of this order may result in prosecution or sanctions against them under Article 71 of the statute. Again, as part of reassuring you against self-incrimination, the confidential transcript created from such testimony of your evidence will be placed under seal and will not be released without a court order here. And the court will apply other appropriate protective measures to any subsequent decisions in order to give effect to this particular order. So all these are things we've gone out of our way to do to ensure that you give your testimony without fear, undue fear, that is, of self-incrimination resulting from what you said. Did you get all of that?
Yes, Mr. President.
All right. Thank you very much. With all that out of the way, I will now hand over the proceedings to the prosecutor.
Mr. President, before that's done, I would ask, reference has been made to Article 70 and that complaints can be made and investigations can be launched for giving false evidence. Your Honour, I would urge the bench to consider informing the witness that Article 70 has a maximum period of imprisonment of 7 years as well as a fine that may be imposed. Your Honour, of course, the rules allow that warning to be given to the witness. It may make the reference to Article 70 a little bit clearer, that it's not only an offence to lie, but it's an offence punishable with imprisonment and or fine.
Mr. Khan, I think enough was said on the matter. Let's leave it at that. Witness heard you.
Your Honour, since my learned friend has effectively given the warning already, perhaps I should correct him.
All right, we will, because of the video has been frozen for so long, it makes the court officer should try and attempt to reconnect it.
I'm grateful. And Mr. President, just for clarification, of course it's imprisonment or fine. But Your Honour, the reason I raised it was simply the terms of the rule that made it a mandatory obligation for the witness to be warned of the provisions of Article 70 and the consequences of a potential consequence of breaching those requirements and giving false evidence. Your Honour, ordinarily the bench hasn't required it because all of that is explained to the witness, we're told, and undertakings are given. But because that doesn't seem to have been the case, I was just trying to be cautious and advising that the witness be informed. I just wanted to explain my position. I'm grateful.
We gave a specific direction, didn't we, to the council? Mr. Mutai?
Well, yes, given,
Your Honour, I think my learned friend didn't refer. He didn't say that he had given the instruction under Article 70 in the terms that are required in the rules, but I'll say no more.
Mr. Mutai, what's the situation?
Mr. President, I explained to the witness about the provisions of Article 70, the penalty under Article 70, Sub-Rule 3. That is the possibility of 5-year imprisonment or fine, and also the provisions of Rule 74 on self-incrimination. All those have been explained to the witness.
I thought I understood the matter in that way. Mr. Steinberg, you were saying something?
Well, although the record hasn't correctly captured it, Mr. Mutai has clarified the penalty is not in fact 7 years, but 5 years. I don't think the record said fine, but I understood Mr. Mutai to say 5 years or fine.
All right, let the court officer redial the line and then we'll proceed.
Yes, Mr. President, we will redial right now. Mr. President, we are back and we can see you and hear you right now.
Thank you very much. Mrs. Steinberg, please proceed with your examination, Chief.
Thank you, Your Honours. May I just confirm that the bench has before it copies of the prosecution PIS and the binders that were handed out?
How many binders did you hand up?
It should be one for each judge, Your Honour.
Yes.
Your Honour, the PIS form has also been provided electronically to the CMS representative at the remote location. I understand that for security reasons they propose to show it to the witness in electronic rather than printed form. And may I start by then asking the CMS to call up the PIS and in particular the page 5 of that document.
understand, and when we are in public session, it is red. But when we are in private session, that button lights up green. Witness, you're not in the courtroom, but I want to ensure, I want to inquire whether we have the same arrangement on the other end.
Mr. President, if I may intervene.
We're now in public session, but yes.
Yes, we have the same arrangements in the sense that everybody here can see in the transmission whether we are in closed session with the CS initials, private session, PS initials, and no initials at all, means that we are in open session, and this has been explained to the people that are here.
Yes, and the witness understands it?
Yes, Your Honor.
All right. So watch out for that system, witness, and so that also, you will hear announcements being made by court officers when we're going into public session and when we're coming out and going into private session. You will be hearing the announcement, but also please keep an eye to the physical system you have over there that will assist you. We'll go into private session now and try that system out.
We're in open session, Your Honours.
Thank you, Mr. Witness. Are you with me?
Yes, I'm with you.
Have you now had an opportunity to peruse the personal information which appeared on the PIS sheet displayed to you on the screen?
Yes. Yes.
And what are your observations, if any, on that information? Is it correct, or is there anything you would like to change? Mr. Witness, is that information correct? Can you confirm that, please?
Yes.
Thank you very much. Now, without giving specifics of your exact address or exact suburb where you lived, which area were you staying in 2007?
Yeah, I was in Kapchabe.
And is it correct that is in the Rift Valley?
Yes.
And I note that from the information you've given in your CV, there seems to be a gap for the year of 2007. And, Your Honours, I'm afraid I'm going to have to ask to go into private session for approximately 5 minutes.
For about 5 minutes. Private session then. We'll try and make it sooner than that. But come out sooner than that is. But we'll go into private session for now.
We're in open session, Your Honours.
Thank you. Mr. Witness, can you please tell the court what was the atmosphere like in Tarbo in the months leading up to the 2007 election?
The tension was very high towards general election.
And in particular, what was the atmosphere like amongst PNU supporters in Turbo at that time?
There was a kind of hatred between the PNU supporters and the ODM supporters.
Just to make sure I heard you correctly, did you say a kind of hatred?
Yes.
And in general, which ethnic groups were supporting the PNU and the ODM respectively in Turbo at that time?
The PNU supporters were majorly from the Kikuyu community. And then for the ODM, we had the Kalenjins, the Luyas, and the Luos who were found in Turbo.
And tell the court, please, well, firstly, is it correct that there were some Kalenjins who supported the PNU, although the majority supported, as you say, the ODM? Is that correct?
Yes, there were some Kalenjins who supported PNU.
And what was the attitude of the Kalenjin minority towards those Kalenjin people who supported the PNU?
Can you take that question again?
Yes, I think it's been either I misspoke or the record isn't correct, but I'll repeat it. What was the attitude of the Kalenjin majority who supported the ODM towards those Kalenjin members who supported the PNU?
Yeah, the majority had negative attitudes toward the minority who supported PNU.
During the election period, that is December 2007 to December 2008, did you remain in the Turbo area or did you leave the Turbo area at any time?
I remained in Turbo throughout.
You're on a private session, please, for approximately 5 minutes. I need to get some details of a relative of the witness.
Private session.
We're in public session, Your Honours.
Mr. Witness, at the time of the 2007 election, which electoral district did Tarbo fall under?
Eldoret North.
And who was the PNU candidate for Eldoret North?
We had a KANU candidate, which was an affiliate party of PNU, and the candidate was Jonathan B.
And were the PNU supporters behind Mr. B as an affiliate of the PNU party?
Yes.
Do you know why the PNU did not have its own candidate for that constituency?
I don't know.
And who was the ODM candidate for that area?
It was William Ruto.
Are you aware, Mr. Witness, whether there was any primary elections for the ODM candidate for Eldoret North, or whether Mr. William Ruto stood unopposed?
He stood unopposed.
Mr. Witness, what can you tell the court about Mr. Ruto's influence in the Eldoret North constituency in particular, and in the Greater Rift Valley in general?
I can say that he is among the leaders that are elected from Rift Valley in general, and I can say that the community, or the Kalenjin community, we rely so much on him as the appointment, since almost every community in Kenya has their appointment.
And can you perhaps elaborate on what you mean by point man?
Yeah, when I say point man, I mean that politically in Kenya, of late we are seeing that it is coalitions which forms the government. So, and before coalitions are being formed, there is some MOUs or memorandum of understanding, those pre-election agreements. So, for the people from Rift Valley, the leader now at the present is William Ruto.
All right. I'd like to concentrate or focus your attention, if I can, not on the present, but on the period leading up to the 2007 elections.
Before you do, the witness, I want to make sure that what you say is clearly captured on the record. So there is MOU, or Memorandum of Understanding. Did you say pre-election agreements or coalition arguments?
Your Honor, I said pre-election agreements.
Pre-election agreements. All right. Thank you.
Yes.
Your Honor, and I believe similarly at line 17 it should be coalition agreements, not coalition arguments.
So that is a correction, isn't it, witness?
Yes, Your Honor.
Thank you.
And this position of point man, as you've called it, what was the Kalenjin word used to describe Mr. Ruto's position in Kalenjin society?
For sure, there is no such a name that is used.
All right, I'll come back to that. And can you give the court any examples of Mr. Ruto's influence in the Kalenjin community at the relevant time, 2007? Did you understand the question, Mr. Witness?
You can repeat again.
Yes, I've asked you certain questions about the influence which Mr. Ruto held in the Kalenjin community. Well, perhaps let me just clarify that. In 2007 now, can you confirm or can you tell the court what was Mr. Ruto's influence in the Kalenjin community in Tarbo and the Rift Valley?
Yes, I can say that the Kalenjin community voted for ODM and the presidential candidate Raila Amolo Odinga because Mr. William Ruto was among the founder members of ODM.
Are you able, Mr. Witness, to give the court any examples of Mr. William Ruto's influence in the Kalenjin community in the period leading up to that election?
I can't.
Thank you. You've told the Chamber that the Kikuyu population of the Rift Valley was mainly supportive of the PNU, correct?
Correct.
And you've told the Chamber that there was a hatred at the time, in your words, between the Kikuyu and the Kalenjin community. Is that right?
Correct.
In the lead up to the 2007 elections, can you tell the Chamber about any incidents or any examples of the problems between the two communities in the Tarbo area prior to the elections?
Can you repeat the question again, please?
Yes. I'll try to make it simpler as well. Can you give the Chamber any examples of problems or incidents involving the Kalenjin and the Kikuyus in the lead up to the 2007 election in Tarbo?
There was no problem before the elections.
Mr. President, perhaps the question could be better clarified. The witness did not testify to the fact that there were problems between Kikuyus and Kalenjins. Witness talked about problems or hatred between supporters of ODM and supporters of PNU. So the question should be clarified, at least along those lines.
So the witness's answer is not sufficient?
Beg your pardon, Mr. President?
The witness's answer to the question is not sufficient?
We would leave it, but I thought perhaps the best situation would have been a clarified question to give the witness an opportunity to.
Thank you, Your Honours. I will take up Mr. Fowler on his suggestion. If I haven't made it clear, or if I haven't asked a follow-up question, did you tell the... Well, you've told the court about a hatred, if my learned friend is correct, between PNU supporters and ODM supporters. Is that right?
Yes.
What was the relationship like in general between the Kalenjin community and the Kikuyu community of Tarbo in the lead up to the 2007 elections?
Yes, the relationship was not good because I had said before that the political tension was very high, and each community was expecting their where they support to win. So there was no that much friendship between the two communities.
And are you aware of any occasions where any public statements were made in relation to the relationship between these two communities?
I'm not aware.
Your Honour, may I briefly go into private session? I wish to ask one or two questions about the witness's capacity at the time of the lead up to the elections, which may be identifying.
How long?
Not more than 2 or 3 minutes, Your Honours.
All right. We go to private session.
We're in open session, Your Honours.
Thank you. And I can repeat that last question. It didn't need to be in private session. Can you confirm that you told the court you were aware of problems that occurred during the course of PNU rallies in the Turbo area? Is that right?
Yes.
Tell the court about those problems, please.
There was a day, I don't remember the date, that the PNU supporters held a rally at Turbo in St. Columban's primary school ground.
Yes, and what happened?
Then now there was some confrontation between the ODM supporters and the PNU supporters.
And what happened?
The ODM supporters shared President Kibaki's campaign pictures that had been mounted on the walls.
They tore down the campaign pictures of Mr. Kibaki?
Yes.
Yes, what else?
Yeah, that is the only thing I'm aware.
You spoke in your previous answer about confrontations between the ODM supporters and PNU supporters. What confrontations were those?
The ODM supporters were saying that the meeting should not take place, while the PNU were saying the meeting should take place.
Yes, and what happened during the course of that confrontation?
The police came and calmed the situation.
Was there any violence at that time?
There was no violence.
Very well. Now, did you ever attend any rallies held by the ODM?
I never attended.
You've told the chamber that Mr. Ruto was the ODM candidate for the area. That's Eldoret North. Did you ever hear Mr. Ruto speaking publicly during the campaign period?
I didn't hear him.
Were there any other occasions other than political rallies where you heard Mr. Ruto speak, where you were present when Mr. Ruto was speaking publicly?
No.
Court will bear with me, please. All right. I'll come back to that point in a moment. So you've told the chamber today that you're unaware of any incidents between the Kikuyu and the Kalenjin community in the lead up to the 2007 elections. Did I understand you correctly?
Yes.
What happened after the elections? The election was on the 27th of December 2007. Were there any incidents that you witnessed or are aware of that occurred after that?
There wasn't.
Let me just clarify, because I've actually asked you two questions. Did you witness any incidents after the 2007 elections between the Kalenjin and the Kikuyu communities in Turbo or around Turbo?
I didn't.
And do I understand from that answer that you didn't witness any violence in or around Turbo after the 2007 elections?
Yes.
Were you aware of any violence taking place that you did not personally witness?
Yes.
And from where did you get that information?
Yeah, I had people saying, and also, yeah, I had people saying.
Saying what, Mr. Witness?
Talking about the violence that had happened.
Who are these people?
Yeah, my neighbors.
Your Honor, I wish to discuss a few names that may be identifying. I wonder whether I might go into a private session again for 3 or 4 minutes.
Private session.
We're in public session, Your Honours.
You referred a while ago, Mr. Witness, to a negative attitude towards... Bear with me, please. Let me check the record, Your Honours, so I don't put anything incorrect. Yes. In fact, you said that the majority of the Kalenjin population in Tarabo had a negative attitude towards the minority who supported the PNU. I'm referring to record page 64, lines 20 and 21. Can you give any examples of that negative attitude towards PNU supporters by the Kalenjin in the area?
I can say that it has been common that whenever we go for elections, the parties that are contesting, and I can say those who are hotly contesting, tend to not to be friendly to each other, because every group expects the other one to be a winner. And concerning what you have asked me is that you feel when you are with the people, then especially maybe in groups in the drafting centers, you find people talking bad about a certain party and talking badly about those people who support the party.
And when they were talking badly about, well, let me confirm, are you referring to the Kalenjin people talking badly about PNU supporters? Do I understand you correctly?
It was two-way traffic. The PNU supporters talking badly about the ODM and the ODM talking badly about the PNU.
Right. And what were the ODM supporters saying about the PNU supporters?
Okay, yes. Since I had said that there was ethnicity between the Kalenjins and the Kikuyus, so the ODM supporters were blaming the PNU supporters for supporting the Kikuyu community.
Thank you. Your Honours, I noticed the feed is frozen again. It would be helpful to me if we could re-establish the feed.
The audio seems to be working. You want the video as well?
Your Honour, yes. I think it is not unreasonable to ask that I'm able to observe the demeanour of the witness, particularly in these circumstances.
I didn't say it was unreasonable. I was just pointing out whether you want us to pause. Okay, you want the video. Okay.
I'd ask the link to be re-established, please, Your Honour.
We will redial, Your Honor.
I'm grateful, Your Honours. We seem to be back online. Your Honour,
Just so on that matter, it's a delicate situation we're dealing with, delicate from the technology viewpoint. So we will not be stopping every time to retire. If we can get audio from time to time, we will. But given the frequency of the freezings we've seen so far, we will not be stopping every opportunity. So,
understood, Your Honours. Thank you. Your Honour, one last, I note the time, there's one last aspect that I will need to deal with in private session before I move on to the next phase of my questioning. May I ask then private session for no more than 5 minutes?
That takes us then to lunchtime?
Hopefully, yes, Your Honour.
All right, we'll go into private session.
All rise. We will obey. Please be seated.
We are in open session, Your Honors.
Thank you very much. We adjourned in private session. There was a matter that arose then, and the chamber will go back to private session now to make a ruling on that matter.
We're in open session, Your Honor.
Thank you, Your Honours. I won't spend too much more time on this, but the question I'd asked, I may as well get the answer, was whether you had heard this large group of Kalenjins, armed Kalenjins you saw on the 31st, say anything or make any noises.
No.
You did tell the court a moment ago that you had recognized certain people but could not remember their names today, correct?
Yes.
At the time when you made your statement in July 2013, did you remember those names?
Yes.
And did you tell those names to the investigators who took your statement?
Yes.
Very well, I'll come back to that. Now,
was fill or feel. Counsel?
thank you, Your Honours. Did you use the word fill, F-I-L-L, or feel, F-E-E-L?
F-I-L-L-E-D.
Perhaps, Mr. President, perhaps it needs to be clarified whether he was told to fill in that information in the diary or it was his own decision to fill that information in the diary. It's not clear in the record.
we're taking it one at a time. We wanted first of all to know what word he was using, and then I think follow-up questions as well.
Thank you. Now, I'm taking it from page 98, line 20. You said, I left my diary at home, so they told me. Are you referring to the investigators when you say they told me?
Yes.
They told me that when coming, bring the diary so that we can fill to concur with the statement.
Yes.
So the first question is, where were you when you filled in these entries? Were you at home or were you at the location where you met the investigators?
At the location where I met the investigators.
And when you filled this information in, where were the investigators?
I was with them.
They were present?
Yes.
The information which you filled into the diary, was that correct or incorrect?
Sorry?
Yes, the investigation that you filled in the diary in the presence of the investigators, my question is, was that information correct? Was it true? Or was it false?
Some were true, some were false.
And did the investigators know that part of the information was false, according to you?
Yes.
And why were you filling in false entries in this diary?
It was to concur with what I had told them before.
In your statement?
Yes.
And what you told the investigators in your statement, was that true or was that false?
Some of the parts are true, some parts are false.
And why did you record false information in your statement to the investigators?
Sometimes back in April last year, that is 2013, I was approached. I don't know if I should mention the name publicly.
You shouldn't mention the name. Approached by, was it a man or a lady?
A lady.
We'll get that information in private session, but for the time being, carry on with your story.
So she told me that she had been approached by investigators from the ICC that they still needed some more witnesses to testify against William Ruto and Joshua Sang. So she told me that it was good for me to join in giving that statement, even if it is false. There is no problem. She told me that if I give out that statement and I am approved to be a witness, I will get many privileges. One, she told me that my children are going to be given free education by the ICC. She told me that I will live a very comfortable life outside Kenya and in any country of my choice. And that I can pursue my education while the ICC will be paying for me the school fees. And then finally, which is a personal issue, was because I've been against Ruto from the beginning, naturally. So that hatred that I had on Ruto also provoked me to give false statement.
So were those your reasons for giving a false statement?
Yes.
Were there any other reasons?
Maybe just to add on that is that personally, my earning was very low, so I took it to be fantastic if I can get my children going to good schools, living a comfortable life outside Kenya. Yeah, and then I saw as if it was a privilege to me. And then she told me that this is the only opportunity. If we don't utilize this opportunity, I don't believe any other opportunity will come.
I see. And those are your reasons for giving a false statement, correct?
Exactly.
Just so we can all be sure we're talking about the same statement, I'd like to ask the court officer, please, to call up the front page of this statement for the witness to identify. At this stage, only for identification purposes. The court will bear with me. So, Mr. Court Officer, kindly call up ERN KenyaMOJA 0109 0019, and it's R01.
I take it the material will be displayed in the courtroom only?
I presume so, Your Honor.
That would be the case.
Your Honours, this is at tab 1 of Your Honours' binders. And if I may ask the court officer to inform us when the witness has that before him.
The witness is being showed the document as referred to by counsel, first page, ending in 0019, redacted version.
Thank you, Mr. Court Officer. Mr. Witness, and we are in public session, but is that your name that appears at the bottom of the page?
Yes.
And is that your signature and the date of your signature to the right of your name?
Yes.
And below your name, there are two further names. Who are those two people? Without mentioning their names, what was their part in this statement?
They were investigators.
They're the investigators that interviewed you and took this statement?
Yes.
And above your names, it's reflected the statement was taken over 3 days, from the 6th to the 8th of July 2013. Is that correct?
Correct.
Very well. Mr. Court Officer, can I please ask you to then just display the last page of the statement? The final 4 digits of the ERN are 0050.
It is being displayed.
Mr. Witness, can you again confirm that that is your signature and the date of the signature on the last page below the witness acknowledgement?
Yes.
All right. And so we're all clear, this is the statement that you say you gave false information to the investigators in. Correct?
Yes.
Since you gave this statement in July 2013, have you ever told Well, is it correct that you've been in communication with other members of the prosecution besides these two investigators that took the statement?
Yes.
And have you ever told any of those people that the contents of the statement are, in part at least, false?
I haven't.
Is it also correct that between the time you gave this statement and present, you have had certain dealings with members of the Victims and Witnesses Unit of the ICC?
Yes.
Is this on more than one occasion?
Yes.
Are you aware, sir, that the Victims and Witnesses Unit is not part of the prosecution? They're responsible for the protection of witnesses. Are you aware of that?
Yes, I am aware.
Did you ever tell any person from the VWU that the statement you'd given to the prosecution was false in parts?
I haven't.
Sir, the prosecution was recently sent a copy of an affidavit which purports to have been attested by you on the 11th of August 2014. Did you attest to such an affidavit on that day?
Yes.
And on the face of that statement, it appears to have been made before a lawyer from Kipsang and Mutai Advocates. Correct?
Correct.
And in fact, it appears to... Sorry, I'll start that one again. Now, this statement was made less than 3 weeks ago. I presume you're familiar still with the contents. Is that correct?
Madam?
What do you mean statement? You mean statement or affidavit?
I beg your pardon.
Not that they may not mean the same
Yes.
thing, but since you've been using certain terminology, it might be to be precise and true.
Yes, Your Honours, I will try to refer to this as the affidavit, since it has been sworn under oath, and the statements made to the prosecution as statements. This affidavit was made less than 3 weeks ago, Monday, just over 2.5 weeks ago. Is that right?
Yeah, right.
Do you still recall now, less than 3 weeks later, what you said in the statement?
In the affidavit?
Sorry, in the affidavit. Do you understand?
Yes.
And what's your answer? Do you remember?
Yes, I remember.
All right. And just for identification purposes, I again just like to call up this document. And the ERN is KenyaMOJA.com 01351135, but the first page of the document is in fact 1137, and it's not redacted. Mr. Court Officer, could I please ask you to call that up?
Is it in your bundle?
Yes, Your Honours, it's the last document in my bundle, tab 68. And Mr. Witness, for the time being, all I'd like you to do is look at the name and confirm that is your name on that page. Please confirm.
Yes, it is.
Thank you, Mr. Court Officer. Please then call up the last page of the affidavit, which I believe is 1139.
I have with me page 1140. which correspond to the last page of that document.
Thank you.
113.
1140 it is then.
The affidavit?
Of the affidavit. The court will bear with me, please. Unfortunately, the version I have does not have an ERNN on it.
What we have as 1140 is a handwritten letter.
Yes. No, in fact, the page I'm looking for is 1139. That's a separate document.
Page 1139 is being shown.
Thank you. Do you see your signature there too, sir?
Yes.
There is a stamp that appears to be a stamp of S. Kibera Minor, Advocate, Commissioner of Oaths and Notary Public. Is it correct that you were administered the oath?
Yes.
And you swore that the statement was the truth?
Yes.
Who actually drafted the statement, physically did the typing of it? Drew up the statement on your instructions?
Pardon?
Who drew up this statement?
Yeah, I instructed my lawyer.
Which lawyer was that?
He's called Gregory Mutai.
All right. And that is, in fact, counsel who's representing you today, correct?
Yes.
Then one last document to identify. If you could now call up 1140, 11 ERN 1140, which is the last page of the bundle. That appears to be a handwritten statement also by yourself, and you confirm your signature and ID number at the bottom.
Yes.
All right. Thank you. Those can be taken down, Mr. Court Officer. Now, you recall what you said in the statement. You said, and in fact, you confirm under oath in this statement that certain of the details you gave prosecution investigators in July 2013 was false. Is that right?
Yes.
Again, Steinberg was referring to the affidavit.
Yes. Yes, my apologies. All right, let me just move away from that for a second. Since your appearance before this court on Monday this week, have you had occasion to speak to members of the VW, Victims and Witnesses Unit?
Yes, we are talking with them. Mm-hmm. I'm talking with them.
And did members of this unit convey to you a request by the prosecution to hold a witness consultation, witness preparation consultation prior to your evidence? Did that happen?
Pardon?
Do you understand the question?
No, I want them to repeat, Your Honor.
I'll try to rephrase. Did members of the VW convey to you that the prosecution wanted to meet with you to conduct witness preparation?
Yeah, they told me on Monday.
And what was your response to that request?
I told them I am okay.
What does that mean? Did you or did you not want to meet with the prosecution?
I didn't want to meet with the prosecution.
And why is that?
Because I had written a letter withdrawing my statement.
All right, thank you. The court will bear with you one moment. Yes. Your Honours, I believe we've reached a stage where the prosecution is constrained to make an application. The first order of business is to consider whether it's appropriate to make that application in the presence of the witness. In my submission, certain matters which are likely to be debated may foreshadow questions which might follow later on, and for that reason I would ask that the witness be excused for the purposes of any debate that there may be about this application. Of course, I have no objection to counsel remaining, counsel Mr. Mutai.
Defense, do you have any difficulty with that request from the prosecution?
No objection, Mr. President.
Mr. King-Katwa?
I do not have an objection, though the nature of the application to be made has not been stated. We can only conjecture what it is.
All right. The chamber grants the request for the witness to be excused for a moment while the lawyers debated a certain technical legal matter. Witness 604, the registry representative would take you out of the room for now. Just wait for us, and we will call you back in.
Okay, thank you, Your Honor.
Thank you.
Mr. President, the witness has been escorted out of the transmission room.
Thank you. Please proceed.
Thank you, Your Honours. Your Honours, this witness was called by the prosecution on the basis of...
We are in open session.
All right, sorry, there was some interference in my headphones. The witness was called by the prosecution, Your Honours, on the basis of information, evidence he provided to the prosecution previously in certain statements in July 2013. It is now apparent, Your Honours, that he no longer stands by that evidence, and he has indeed recanted that evidence. He has since attested to an affidavit this year under oath in which he recants material portions of his evidence, and in particular portions of the evidence which are relevant to the roles ascribed by the prosecution to the two accused before court. So there is little doubt in my submission that the witness's evidence is certainly now adverse to the prosecution's case. Further to this, Your Honour, the witness has, in his statement, ascribed actions to prosecution investigators which, if true, would amount to crimes, serious crimes. Your Honours, I'm seeing a disconnect message.
Mr. Mutai, can you hear us?
Mr. President, I can hear you.
Thank you.
I'm grateful, Your Honours. Yes, so he's not only recanted his earlier version, but he's made allegations of improper and indeed illegal conduct on behalf of members of the OTP. Finally, Your Honour, he has refused to meet with the prosecution and broken off all contact with the prosecution. Your Honours, the prosecution has not, in the circumstances, gone through the intermediate step of refreshing the witness's memory from the original statement, since he has already clearly stated under oath that that statement was false. I submit that that would be an exercise in futility. Your Honours, the declaration of witnesses as hostile for the purposes of permitting the calling party to cross-examine is not a novel matter, neither in this court nor in domestic jurisdictions.
There are some tests that should be applied.
Yes,
they're not. Okay.
There are, Your Honours, and I will
Let's hear those.
Address those at the moment. Chamber will bear with me. I refer in the first instance to a judgment in the case of the prosecutor versus Thomas Lubanga Diallo, and it's ICC 0104 0106 2201 redacted, dated 2nd of February 2010, where at paragraph 19, His Honour Sir Justice Fulford remarked as follows: the reality of the current position, I beg your pardon, let me start a little bit further down.
Do we have that material?
No, Your Honours, I'm afraid we haven't put court records in the bundles.
Well, the practice normally isn't it the case that people should hand up material that legal authorities to judges so we can see them, unless you want us to adjourn and go and review the material from our own research.
Your Honours, my understanding was that the practice would be to hand up material that was not part of the ICC jurisdiction if it was from some other. But I understand the practical difficulties.
It is a practical difficulty. Even in this case alone, we have made, if you started counting, I do not remember how many rulings we have made. It would be too much to expect that every ruling we have made, that we should have videographic memory of it at every time, let alone case law of other chambers. So that, yes, we can look at them if there had been submissions made earlier in writing, but if you are speaking to the matter on your feet, it's best to hand up those materials so we can be looking at them.
I'm afraid I don't have copies immediately to hand, but within a few minutes I could get copies like that if the Chamber is minded to
proceed.
But let me read verbatim what it says, and it will then be on the record. From halfway down, paragraph 19, the learned judge says, additionally, given the wholesale change of account, it would be unfair to the prosecution and it would potentially impede the Chamber in its pursuit of the truth if the prosecutor is at this stage restricted by the limits that are traditionally imposed on, quote, examination in chief, unquote. And then at the end of the paragraph, in these particular circumstances, it is undoubtedly appropriate for the prosecution to ask closed, leading, or challenging questions as necessary. If the prosecutor is restricted to neutral questions, he will be unable to explore adequately the circumstances of the change of account and the reasons for it. Your Honours, as in the case quoted, the witness at hand is undoubtedly given wholesale change of account.
Let us understand what the authority you have read says. The reason I say it, you began your submission Yes. You began your submissions by announcing that declaring a witness hostile is nothing new. You said the same thing as requesting to ask a witness leading questions.
Your Honours, practice differs in various jurisdictions on this point. In certain jurisdictions, it's sufficient that the witness has given a version which deviates from the version given to the party calling it. In other jurisdictions, certain additional indicia are required. in my respectful submission, in the case at hand, in the Lubanga case, in the Lubanga case, no such additional indicia were required. And my submission is that this is also consistent with the practice at the ad hoc tribunals, in particular the ICTY. And further on in this judgment, at paragraph 20, the Chamber quotes from various, or refers to various judgments in the ICTY, the judgment of the prosecutor versus Halilovic, and this is at footnote 34. Where
I'm not sure that you understood what I was saying. Maybe I wasn't clear enough. What I was saying is the authority you read out says it is undoubtedly, quote, it is undoubtedly appropriate for the prosecution to ask closed, leading, or challenging questions as necessary. If the prosecutor is restricted to neutral questions, he will be unable to explore adequately the circumstances of the change of account and the reasons for it. Unquote. Isn't that the point of the ruling?
Indeed, Your Honours, but the purpose in my submission for a declaration of hostility of the witness is in order to permit the calling party to cross-examine that witness through the normal techniques of cross-examination, including challenging questions, closed questions, and leading questions. And that is where I'm heading with this.
I'm not sure it's the same thing. You don't have to declare a witness hostile to ask them leading questions, do you? Yes, of course, if you declare a witness hostile, you can do all of that. But it is possible to just zero in on your need for leading questions without incurring the tests for leading questions as such. I don't know if you get my point.
I understand the distinction, Your Honours. However, in present circumstances, perhaps the argument is moot, because in my submission, this witness is undoubtedly a witness who would qualify as a hostile witness.
And that's another matter, so you can argue that. And I thought you were going to bring out in the Lubanga decision the circumstances in which the witness was declared hostile, if the witness at large was declared hostile.
Your Honour, the request was not framed in those terms. In fact, the request was titled "The Request on the Manner of Questioning of Witness 15" in that case.
So it was not a declaration of hostility at large?
No.
Yes, that's what I thought.
Yes. Returning, though, to my reference in footnote 34 to what is meant by a hostile witness and the jurisprudence of the ICTY in that regard, it refers to, the learned judge refers to the decision in Halilovic, which states that a hostile witness is one who, quote, testifies in contradiction with his previous statements, unquote. In Prosecutor versus Radoslav Burdanin, it was said that a hostile witness is one who is called by a party under the assumption that the witness will give testimony favorable to that party, but in fact the witness, quote, becomes a hostile witness, saying exactly the opposite or refusing to answer questions which the calling party knows he or she has got a very straightforward answer.
See, a number of concepts were rolled into that very last thing you read in. Giving unfavorable testimony need not be an indication of hostility, is it? Or need the witness have done something else, refusing to answer questions.
Yes. Your Honours, I would submit that he doesn't need to. It's not simply a question of giving evidence which the calling party did not expect. That may be explained by a number of reasons, lapses in memory.
Not what the calling party did not expect as such, but unfavorable testimony doesn't make a witness a hostile witness.
Well, it would seem that according to the jurisprudence of
yes, according to the first. Did you say Ililich?
Halilovic.
Halilovic. That is what it says. Yes.
Yes.
But are we bound by that?
Of course not, Your Honour. No.
Thank you.
The submission of the prosecution, however, is that the weight of authority in the ad hoc tribunals is that it is sufficient for a witness to contradict his earlier version to be declared hostile. But in the present case, perhaps it's not necessary to debate too fine a point on that, the witness has gone further. And apart from disavowing material portions of his original statement, he's made allegations against the conduct of the members of the prosecution, as well as his refusal to have any contact with the lawyers of the prosecution, which, in my respectful submission, show very well that he is adverse or hostile towards the prosecution as such.
Right. Now, if a witness, taking those two grounds you posited, and of course I'll be hearing from the defense later, let's take the matter of refusing to meet with the prosecution. If a party in a case invited a witness, the witness is in your interest that I meet with you and prepare you. Say, no, I don't need it, say the witness. I'll meet you in court. Let's assume that that is the case. I do not want to meet you before court. I will come to court and testify, but I don't want to meet you. Does it make that a hostile witness?
On its own, perhaps not, Your Honours, but it's obviously the combination of factors. And, I mean, I could perhaps have started with the fact that the witness had to be brought to court under compulsion after refusing to cooperate and come to court voluntarily, notwithstanding his earlier indication that he would. So that, together with his recantation, together with his accusations against members of the prosecution, together with his refusal to have any contact with the lawyers from the prosecution, Your Honours, I submit, combined, provides a compelling example, and I can scarcely imagine, short of a witness abusing the prosecutor on the stand, I can scarcely imagine a much more compelling case for the declaration of a witness as hostile.
Is it a small matter? You threw in that last bit as if it was something casual, but is it that casual? Is there a difference or not between a witness who might have said something to give the prosecutor reason to suspect that this might be a hostile witness by writing something that is not part of the record to begin with, directed to the prosecution or the party intending to call the witness before the witness actually comes to the courtroom? Does that sort of material necessarily follow the witness to the witness stand, or is more required to establish that, yes, the abusive communication that a witness made before coming to the court, that he has indeed continued to make such abusive allegation against the party?
Your Honour, if it was sufficient just that, if one can call it an abusive communication, I refer to the affidavit where serious allegations are made, if it were sufficient that that was enough to declare hostile, then I could have made the application before the witness even got into the witness stand. But in the prosecution's view, the witness should always be given the benefit of the doubt to start with. But now that the prosecution has, before the court, under oath, confirmed the contents of that affidavit, including those allegations, and indeed repeated allegations that members of the prosecution had told him to fill in false statements in his diary, to reconstruct his diary, to coincide with his statement, in my respectful submission, is sufficient to show that he is hostile to the prosecution. There are certain jurisdictions where the demeanor of the witness in the witness box is a factor which is taken into account and to which some importance is given in deciding on a request to declare him hostile. But in my submission, the weight of the jurisprudence in this court and before the independent tribunals is that that additional factor is not a prerequisite, where in these circumstances at least the witness has recanted, made allegations against the party calling it, and refused to cooperate with the party calling it. Your Honours, the purpose of all of this is obviously to request that the prosecution be permitted to cross-examine the witness on his latest version and on what is recorded in his first version, and to explore where the truth lies. The prosecution will, during the course of this exercise, request that the statements referred to be admitted for the purpose of impeachment at this stage, not for the purpose of the truth of the contents. However, the prosecution has made it very clear that in due course, and if it can establish that the reason for the witness's recantation was due to or materially affected by improper interference, we will be requesting that the statement be admitted under Rule 68 for the truth of its contents. And I make that point pertinently because it may instruct my learned friends as to questions they might wish to put to this witness in cross-examination, bearing in mind that the prosecution does intend to rely in due course on the content of the original statements.
Thank you very much. Mr. Khan.
I'm grateful, Mr. President, Your Honours. In our respectful submission, the application by my learned friend is not only poorly founded in law on the present facts, but in any event, taken at its highest, is premature. Your Honour, if one goes back to basics, because the issue of hostility, and for that was his application, is effectively a concept that derives originally from the common law, for understandable reasons. And the rule is that generally a party, a calling party, is not allowed to impeach one's own witnesses. And in circumstances where a calling party effectively is taken by surprise, with an account which they did not expect, the common law had sufficient flexibility that it allowed that calling party not to be ambushed or taken by surprise, but to test, by leading questions after a declaration of hostility, the witness's account, effectively to neutralise often exonerating evidence. I pause there for a moment. In assessing the merits or otherwise of the application, it is important in our respectful submission to note that the witness thus far has not exonerated Mr. Ruto. It's very important. He may not have given evidence that the prosecution want. Of course, he wasn't proofed. But he's given, we say, so far, it appears, a truthful account, and that's important. For what is the standard? We say, Your Honour, before, and if my learned friend, and Your Honour is quite right, it is permissible to ask leading questions, even absent a declaration of hostility, in circumstances, for example, where the defence by consent says something is not an issue. By consent, of course, to save court time, leading questions may be asked, but not where the purpose is to discredit one's own witness, where the purpose is to discredit one's own witness, the rule of hostility is important because it goes to the truth-seeking exercise that the prosecution has repeatedly said it's interested in. And in determining the merits or otherwise of the application, Your Honours, it is important that unlike the Lubanga case that's cited, the prosecution was forewarned on the 11th of August 2014 at the latest that the witness had repudiated a previous account. And notwithstanding that repudiation, the prosecution maintained that it wished to call this witness, call him to knock him down, to discredit. And, Your Honours, we say that poses an ethical issue, because with the assistance of this chamber, the prosecution, after 10 long, painful years, finally enacted a code for professional conduct for prosecutors. And, Your Honour, paragraph 63A of that, chapter 4, section 2 of the Code of Professional Conduct. Prosecutors are enjoined, and they publicly have stated, that they must not present evidence knowing it to be false or forged. And that admonition is repeated later on in paragraph 71, that the prosecution must not present evidence knowing it to be false or fabricated. And yet here we have the prosecution, despite an affidavit, bringing a witness and now seeking to discredit that witness, we say.
Have they presented evidence, or are they seeking to present evidence knowing it to be false?
Well, Your Honours, they've called a witness knowing that the witness has given an account which repudiates a previous narrative and which the witness has stated under oath. And knowing that, the prosecution take the risk, we say, that that's the substance of the testimony. Now, Your Honour, importantly, unlike prosecution witness 16, where the prosecution have said we're investigating, they haven't critically sought to investigate the veracity or otherwise of the account. They've jumped, and we say it's lazy prosecution, I'm sorry to say. They've jumped and said we intend to confront him with a previous statement, and we may later confront him with other evidence showing foul play. Your Honour, as a matter of principle, we say, given the importance of Article 54, it doesn't go into hibernation at the commencement of a trial. It remains wide awake, or it should if it's properly applied, even now. And the prosecution have a duty to get to the truth, even when a witness is in the box.
Ms. Gang, can you limit yourself to the application to declare the witness hostile? It looks like you are bringing in a lot of things, including what might, if you boiled it down, be possibly revisiting the question of whether the subpoena decision was properly grounded or should have been made. Let's just limit the submissions to whether or not this witness should be declared hostile, and what do the law, as you know it, said.
Well, Your Honour, I'm grateful. I'll be so guided. I've said at the outset the origins of the rule, which is important to its application. Your Honour, in the Katanga case, it's a decision of the trial chamber in the hearing, Tuesday the 9th of February 2010, at page 20, and I have a copy here for Your Honours if you wish. The chamber stated something which is well known, we say. The chamber, and I quote, at lines 11 to 14 of page 20, the chamber would like to stress that the simple fact of sometimes having unfavourable answers is not in itself enough to mean that a witness is declared hostile. Your Honours, in assessing hostility, we say the prosecution need to establish one of two things. Either that the witness displays a hostile animus to the prosecution in the sense of being undesirous of speaking the truth.
But the prosecution is saying, in terms of hostile animus, that the witness had made unsavory allegations against the prosecution. Does that not count? Or rather, allegations of illegal and improper conduct, to put it precisely, against the prosecution that was done in an affidavit, and while on the witness stand, the witness admitted that he indeed did swear the allegation, an affidavit saying those things.
Well, Your Honours, on that issue, then we go back to what's the purpose of all of this, because a declaration of hostility is not meant to simply neutralise a witness. Sorry, it is a process to neutralise a witness that's exculpated an accused. Your Honour, if there's an ancillary issue that the prosecution have got certain allegations, there's two matters. The first is, I note, the prosecution didn't really ask what I would say of detailed questions on that issue. They touched and went, so to speak. They touched and they didn't probe in a necessary manner. But secondly, that's a complete red herring. That's a complete red herring. And we say what's important is Your Honour's own assessment, not the prosecution, not the fact that he may be an unfavourable witness to the prosecution, because we haven't even seen that. It's Your Honour's assessment at this moment, is that gentleman who has voluntarily come, albeit with a summons, to give evidence, and for the first time since this hearing started, this trial started, we respectfully submit he was told in underlined terms, in highlighted terms, about the importance of Article 70 and the liability for prosecution for giving false evidence. Is it right to allow the prosecution to declare that witness hostile when so little information has been obtained? Your Honour, it's now respectful submission.
The point you're making, isn't it, is that you started with saying so far the witness has not exonerated Mr. Ruto, your client. So your point, isn't it, is that if there are some discrete items of information, evidence as it were, that go to any such question, the prosecution has not asked those and indicated difficulty getting to those by way of first we try leading questions to see if that could help. Then if during leading questions it becomes clear that nothing works, then we may come to the second option, hostility.
Exactly, Your Honour. That's it in a nutshell. And that goes to my point that in any event it's premature. The prosecution, leaving aside the fact that they're not even attempting to put a statement to the witness as a memory-refreshing document, they haven't even attempted to take the trouble to enlighten Your Honours and all of us as to which parts of the statement are true and which parts are false. And the witness has said some parts are true, some parts are false. And these are not procedural niceties. These are necessary steps, we say, in getting the truth out. The prosecution premature application, we say, to declare the witness hostile is a recipe to stop a full narrative being given. It should be rejected on legal grounds because there's no evidence of a hostile animus or that the witness is undesirous of telling the truth. He's attempting to tell the truth, but in any event, the prosecution haven't diligently asked probing enough questions to separate which parts are truthful in the statement and which parts are not. Those are necessary steps, we say, before jumping the gun, as we say, my learned friend for the prosecution has done in seeking to declare the witness hostile.
Mr. Kikin-Catwell, do you have anything to add to that, and how long will it take you?
With your permission, Your Honours, I am requesting Dr. Buisman to respond to that point.
Ms. Basman, how much time would you need? You see, it's time for us to adjourn for the day.
I would need probably 5 minutes.
All right, Ms. Bassman, we will take your submissions tomorrow morning at 9 o'clock, 5 minutes, and if you have any response, Mr. Steinberg will do it at that time as well. Any reply, rather.
Thank you.
We'll do it at that time. We will now adjourn, and we start again, reconvene tomorrow at 9 a.m., not 9:30.
All rise.